My name is Rebecca Gudeman, and I'm an attorney with the National Center for Youth Law. We'll give you some links at the end so that you can both find out a little bit more about the National Center for Youth Law and more about some of the work and resources we have available in this area. But I'll just say quickly that in addition to working on healthcare access for young people, we also do work in a lot of other spaces: juvenile justice, child welfare, education, immigration. So I encourage you to take a look at our website. In health, I focus primarily on access to healthcare services for adolescents, and a lot of that has to do with consent and confidentiality law. And so through that work, I've gotten to meet a few of you on the phone in addition to the partners I'm working with on this grant, and it's nice to meet the rest of you. All right, let's see. Somehow I'm not able to move my slides, team, so I'm going to just keep chatting. There we go. So as Victor said, I am lucky enough to be a partner on the grants from both Children's Hospital Los Angeles and California School-Based Health Alliance. So just sort of hey and thanks to them for allowing me to be here today. Let's see. Okay, there we go. And because I'm a lawyer, I, of course, always have to say at the beginning of every training that I can provide legal information, not advice. So there will be some times where you might be a little frustrated that I'm not completely answering a question, and that really is a space where I can't cross that line to legal advice. I'll also note that the information provided today is based on the state of California law as of February 2020. And now I wish this were a photo of me up on the slide. If you're looking at the video, you'll see that it isn't quite. Just had to put a photo up acknowledging some fellow female lawyers. If any of you are watching a lot of reruns these days like me, I've been watching The Good Wife. So just figured I'd put a shout out to that show if you haven't watched it before. It's really fun. Okay, so we're going to talk about consent today, but what we wanted to do before we dive in is acknowledge that there are a lot of different kinds of consent. When we say consent, sometimes folks think about consent to treatment, which really is getting someone in that door. How do we open the door so that we can engage them in a patient-provider relationship? Sometimes when people say consent, what they're really talking about is release of information. So we've gotten them through that door. They've engaged in some sort of service. We've created information, and now we want to know who can release that information, how do we make referrals, how do we do collaboration, and we have questions about consent, who can consent to sharing that information that's being created. Another area where people often have what we would call consent questions has to do with insurance, particularly when we have a patient who may be insured on someone else's insurance plan, like a youth enrolled on their parents' insurance plan. There can be questions about consent, who can give permission to use that insurance, what happens with that information. So consent can mean a lot of things. Today we are going to exclusively focus on that first one in our discussion, consent to treatment. How do we open that door to care? We'll talk about the general rules and then spend a lot of time talking about minor consent. When can minors consent to their own care? And then hopefully, if we have time, we will open it up to some questions, ask you to share some of your stories and best practices. And then critically, as Victor noted, part of the work I'll be doing with some of the grantees is trying to create some materials. And so we also have some next steps asking you for some help gathering some information on what are sort of the critical questions and concerns you have in this area. Okay, so without further ado, let's go ahead and dig in. Who can consent for a minor's care? When I say minor, minor in California means anyone who is under age 18. The moment someone hits that 18th birthday, they are considered an adult, and with rare exception, adults consent to their own health care, no matter what kind of health care it is. There are a few rare exceptions. We won't talk about that today, but wanted to just make really clear that right now we're talking about who consents to health care for someone who is under age 18. Our general rule in the state is that a parent or guardian would consent to health care for a person who's under 18, but there are exceptions that allow other caregivers to consent when a parent or a legal guardian may not be available. There also are some special rules for court-involved youth, either youth who are involved in juvenile justice or foster care, and minor consent. We're going to focus on minor consent today, but I did want to just take a second talking about young people in the juvenile justice system, because I know a number of you are working in those spaces. At the very end, I will provide a link to a resource we have that provides a lot more detail about consent to treatment for young people who are in juvenile justice. But just as a basic rule, when a young person enters the juvenile justice system, so either in temporary custody or the court has either place them in a facility or they're in probation, the basic rules for consent still hold true. So if a parent consented to health care before they enter juvenile justice, a parent still consents to care once they're in that system and under court jurisdiction. In the same way, if a minor can consent to a certain type of health care before outside of juvenile justice, even when they're in the juvenile justice system, that minor still has that right to consent. Now, having said that, there are some additional consent rules that allow other people to consent to care in certain situations. So, for example, if you are unable to find a parent and it's an urgent health need, there are mechanisms in the law that allow a probation officer in some circumstances to consent, or more likely get court authorization for consent. I described those in more detail in that link at the end. But it is important to know that the law really tries to keep the rights of parents with parents and keep the rights of minors with minors, and that these are considered exceptions to acknowledge the unusual circumstances when, for example, a young person is in a juvenile justice facility and it is additionally there's an urgent need and we're unable to contact parents. Okay, now what I'd like to do now is talk a bit more about when minors are able to consent to their own health care. In every single state, there are exceptions that allow minors to access health care on their own consent. And in general, the type of those laws can be divided into two categories. Laws that allow minors to consent to their own health care based on their status, their situation in life, and laws that allow minors to consent to health care based on the type of health care they're seeking. So we think that this particular service is so important or so challenging that we are going to create an exception that helps open that door and allows minors to access it on their own. In each state, those rules are a little bit different. So let's walk through what California law says. So for status exceptions, in our state, if a minor is in any of these different status categories, they can consent to health care, medical and dental care, almost in the way an adult would. And those categories are married or divorced, armed, that they're in the armed forces, that they've been emancipated by a court, or that they're 15 or older, living apart from their parents and managing their own financial affairs. Now, often folks say, well, how would we know if someone walking in the door fits one of those categories? As a practical matter, if someone's been emancipated by a court, that means they've gotten an official court ruling that emancipates them. Often they will go to the DMV and get an ID card that says that they are an emancipated minor. They typically will do that because they need that in order to sign leases for apartments or sort of do any of the things that an emancipated minor might want to do. They aren't required to, but they might have that card. But, you know, most of us don't carry our marriage certificate in our back pocket. It's not something that is stamped on our ID cards. So if you are an organization or a clinic that provides services to a lot of folks that you think might fit in one of these categories, it can often behoove you to work with your clinic management and attorney to develop some sort of tool that you can use to determine whether a minor fits one of these categories. I've seen, for example, some county clinics create just a form that they have the youth sign under penalty of perjury, in which the youth sort of attest that they fit one of these categories. Now, for many of you who are working with homeless or transient youth, the final category may be particularly relevant. So if a young person is 15 or older, living apart from their parents and managing their own financial affairs, they can consent to general medical care in the same way that an adult would. Living apart from parents doesn't mean that they have to be living independently of any adult. They may be couch surfing at friends' houses. They may be living with a grandparent. Managing own financial affairs doesn't mean that they have to be fully able to pay for an apartment and all of their needs. What it does mean is whatever funding that they have coming in, they're making decisions about how to spend that money. If you are an organization that provides a lot of services to young people who may fall in that category, this again is an area where it might be really valuable to work with your clinic management and legal counsel to create some sort of a tool to help assess whether someone fits into that category and can consent to care as a minor who's 15 or older and living apart from their parents. Now, if someone doesn't fit one of those categories, they still may be able to consent to their own care if the type of healthcare service they're seeking is in this list. So I will provide an additional link at the end to something that provides these in more detail, but just as a quick summary, minors of any age, there's no lower age category, can consent to any pregnancy-related services or sexual assault treatment. And minors who are 12 or older can consent to outpatient mental health services, diagnosis and treatment of reportable communicable diseases, diagnosis, prevention, and treatment of STIs, diagnosis and treatment of intimate partner violence, and then counseling treatment of drug and alcohol services. And we, of course, will spend a lot more time talking about these two, outpatient mental health services and drug and alcohol right now. Okay, so we're actually going to start with mental health. In our state, there's actually two different laws that authorize minors to consent to mental health services on their own. The first law is in the Health and Safety Code, and it says that if a minor is 12 or older, they can consent to their own services if the minor, in the opinion of the attending professional person, is mature enough to participate intelligently in the outpatient services. The other law is in the Family Code, and it starts out the same. It says minors 12 or older who, in the opinion of an attending professional person, are mature enough to participate in services can consent. But it has a third clause that says, in addition, the minor either must demonstrate that they would present a danger of serious physical or mental harm to themselves or others without access to services, or you know that they're an alleged victim of incest or child abuse, and that is one of the reasons they're seeking care. So Health and Safety Code has a lot less stringent requirements. I'll explain in just a second what why you might want to use one over the other. But first I want to just flag, I know there's always questions, well, what does mature enough mean? This is one of these many places that I'm going to flag where the law actually doesn't provide us a specific definition of mature enough. And that's sort of two sides of a coin. For some folks, that's really frustrating because they want some clear black and white guidance. But when that happens in the law, what it often means is that the legislatures are deferring to the professionals, the counselors, the attending professional person, to make that judgment call. And what they're asking you to decide is whether they're mature enough to participate intelligently in outpatient services. It doesn't mean that they have to be as mature as a 30-year-old, as mature as an adult. It means that they have the ability to engage in the services that you're providing. And the law is deferring to you and your professional expertise to make that judgment call. So, as I said, two sides of a coin. On the one hand, we're acknowledging your expertise, but it can also be a little bit intimidating to have the law say, well, we're going to trust you and not provide you more detail. So if someone meets those criteria, what are they allowed to consent to? Well, if it's under the Health and Safety Code, you're allowed to consent to assessment, outpatient counseling, and outpatient treatment. It doesn't cover inpatient treatment, hospitalization, psychotropic medications, or psychosurgery, which I hope we're not doing too much of, but that's what the law says. And similarly, Family Code says the same thing. If you meet the 3 criteria in the Family Code, you can consent to assessment, outpatient counseling, outpatient treatment, but not inpatient hospitalization, medication, or psychosurgery. Where we do, or actually, let me first, so just quick case to test our knowledge of the 2 laws. 16-year-old Anna walks into a clinic and asks for a mental health appointment. When asked about her parents, she says she doesn't want her parents involved in her care because she doesn't want them to know she's having some anxiety. May the therapist evaluate and possibly treat Anna without parent consent? All right, so I actually don't remember if we had set this up as a poll. Did we set this up as a poll, Kristen? Yes, we did. Okay, so take a second and let us know if you think, oh no, this is not quite yet a poll. Sorry. Yeah, so what we wanted to do, we have so many polls, I couldn't remember which ones we put them on. What we wanted to do with this one is highlight why that difference between Health and Safety Code and Family Code is important. So in both Health and Safety Code and in Family Code, it says you need to be 12 or older, so 16 years old, she certainly potentially qualifies. Both laws require her to be mature enough to participate intelligently, and that would be up to the clinician to make that judgment call. So whether Anna is or is not mature enough is up to the clinician. But the difference between Family Code and Health and Safety Code is Family Code also requires that the clinician make a determination on whether Anna is a danger of hurting herself or others, or is an alleged victim of abuse. We certainly don't have that information here yet, so she may not be able to qualify under the Family Code to consent to her own mental health care, but under Health and Safety Code, a lot lower bar, a lot easier for her to get in that door. So why would we not use Health and Safety Code all the time? Well, one of the reasons has to do with funding. Health and Safety Code explicitly says that Medi-Cal funding cannot be used to pay for services that youth consent to under Health and Safety Code. We don't have that same limitation in the Family Code. And the 2 laws also differ in terms of who they authorize to provide minor consent care. There is a longer list of professionals and agencies able to provide minor consent services under the Family Code than there are under the Health and Safety Code. So that would be something to take a look at. And I do have a lot more information on our website, which I'll provide the link to at the end of this. Okay, so let's move on to substance use exception. Under the Family Code, minors who are 12 or older are eligible to consent to substance use services. That's it. No other conditions or requirements. What does it say? They're allowed to consent to diagnosis of drug or alcohol-related problems, medical care for drug or alcohol-related problems, and counseling for drug or alcohol-related problems. Now, one note on terms. The precursor to Family Code 6929 was enacted in the year 1977, and many of the terms that are still in the Family Code date to that original statute. So I know I'm using terms like drug or alcohol. You'll see me use some terms later on that may not ring well for you if you are sort of working in our new world and our terminology like substance use disorder, but I am sticking to the language of the statute, which dates back to the 1970s. So just wanted to explain that. So with that said, drug or alcohol, what does it mean? The statute does define what that means, and it references several state statutes, penal codes, and health and safety codes to define what kinds of addictions or substance uses that minors can consent to care for. When we translate those down, look into those statutes, what it means is that alcohol, it means nitrous oxide. Don't ask me why, they highlighted that one. And most critically, it means anything that's on one of the Schedules 1 through 5 Controlled Substance Act lists. If you want to see every single medication and substance on that list, we've put up a link right here. It includes cannabis, it includes opioids, it includes most every prescription medication that somebody may end up using or abusing illicitly, but you can take a look at that list. And that is something that minors can, if it's on the list, minors can consent to services related to use. What does counseling mean? Minors can consent to counseling, and it's defined as counseling services provided by folks with certain funding streams. So what's important here is that they don't explain in detail the type of service. What they do is link it back to funding. If it's funded through this funding mechanism, it meets the definition of counseling. And these reference, by and large, reference back to services funded through substance use Medi-Cal, and I think Victor probably could provide some more detail about exactly what that covers. But what's nice to know is that it's not sort of, is it this kind of therapy or that, it's about the funding stream. Medical care, in terms of what minors may consent to, is defined quite broadly, and it may seem somewhat irrelevant to some of the kinds of services you provide, but this is what our state law authorizes minors to consent to. It includes examination, medical or surgical diagnosis, treatment, and even hospital care. Okay, so now we're at our first poll. Jordan's 14. He's seeking help at his local school-based health center. He says he's dizzy, has some stomach cramps, feels nauseous. He admits to having drunk a significant amount of codeine cough syrup earlier in the day. So we have two questions for you. First, may the school-based health center provide a medical exam and engage in services based on his consent? And may they use a screening tool to evaluate whether Jordan may or may not have a substance use disorder? So it looks like we've already got some folks jumping in and answering. Great. We'll give you a little bit more time to place your bets, put your vote in, and then we'll talk about the answer.
Yeah, and for those of you who are like, where's the submit button? There's no submit button. Just click the circle next to the answer that you want to select, and that will automatically submit it. And I see lots of folks are still voting, so I'm going to give you about 10 more seconds to get your vote in before we end the poll. And we're going to close it in 5, 4, 3, 2, 1. Okay, Rebecca, let me broadcast those results, and now everyone can see it. So you tell us what you think about these responses.
All right, great. Well, it looks like in both cases, the significant majority of you voted yes. So let's just walk through why or why not to answer, maybe yes. So if we go back to the statute, it says that minors who are 12 or older may consent. So click Jordan's 14, we've got that covered. He can consent to medical care related to a drug or alcohol problem. Drug or alcohol includes any medication that may be in the controlled substances list. Codeine is in that list, so we've got that checked. And then let's just look at medical care. Medical care includes diagnosis, treatment, and diagnosis. Within diagnosis would be screening tools. So in fact, Jordan is allowed to consent to his own medical exam when it comes to medical care for something that may be a drug or alcohol-related problem, including the screening tool. So the answer in both cases would be yes. Now, I did just want to highlight, I know sometimes people get thrown when I say school-based health center. It's important to note that consent law is the same whether you are in a school-based health program or in a clinic outside in the community. Confidentiality laws might be different in different treatment settings, but the consent law stays the same across these different programs. Okay, so now let's say the school-based health center wants to refer Jordan to a program on campus that provides quote-unquote counseling. Jordan adamantly does not want his parents to know. So our next set of poll questions for you, we have a poll and then the opportunity to provide any comments. May Jordan consent to participate in this counseling without parent consent? What else might you need to know to answer this question? So go ahead and give us your thoughts on this. And if you want to type into the chat box any thoughts on that second question, what else you might want to know, feel free to do so.
All right, we seem to be pretty, I was going to say we're unanimous on this one so far. Now we're starting to see some differences of opinion, and there's some great questions coming in from the chat. Several folks want to know his age. Is he in danger? Is he able to contribute or engage based on his intellectual development? And lots of people are typing right now, so I'll let you all read those. It looks like the votes are still coming in fast and furious too, so let's give about 5 more seconds before we end that poll. All right, I'm going to close it in 3, 2, 1. And the results are now broadcasting, and there are still some comments coming in the chat. Rebecca?
Super. Well, it looks like most of you said that he can consent. So this is an interesting one, and I see all the different chats coming in, and folks are flagging age, is he in danger, his ability to engage. So let's just, this one I like because it allows us to talk about both the substance use minor consent law and the mental health consent law. So let's talk about substance use first. The substance use law allows minors to consent to counseling for a drug or alcohol-related problem if they are 12 or older. There's no requirement that they demonstrate that they are mature or have the intellectual ability to consent. If they're 12 or older, they're allowed to consent. But what it does do is provide a definition of counseling, and that definition of counseling is tied back to funding. So if Jordan wanted to consent to this SUD counseling, we would need to know what is the funding stream for that counseling. Is it within that definition that we had on the previous slide? Now let's say this isn't something that is fits within that definition, that is funded through one of the appropriate funding streams. That's where that mental health minor consent law could become really important. So this may be a service that's being provided by the school and funded through the school or through some sort of public mental health dollars rather than through a substance use funding stream. If so, then we could look at our mental health law, which says that Jordan needs to be 12 or older and mature enough to participate intelligently in treatment. So those of you who flagged age and in maturity, that's exactly right if we have to look to that mental health law to see if he can participate. So just really wanted to use this case to highlight how we might, even if this is ultimately for a substance use disorder, might be toggling back and forth between those laws. Now, there are some services that do require parent consent. That parent consent is always required if a minor is under 12 years of age. And parent consent is also required for quote-unquote replacement narcotic abuse treatment. And we'll talk about that in just a second. But I did want to also additionally flag This phrasing, which comes from the SUD minor consent law, it explicitly says that it is the intent of the legislature that the state shall respect the right of a parent or legal guardian to seek medical care and counseling for a drug or alcohol-related problem of a minor when the child does not consent to medical care and counseling. So even if the minor has a right to consent, if the minor, let's say a 16 or 17-year-old, is refusing treatment, the parents do have a right to consent for services and engage services for their child. Now, this certainly can raise some ethical and sort of logistical challenges for those of you providing services, but wanted to flag that this is part of this law. It's the only minor consent law that has language like this that gives parents a right to explicitly overrule their child's assent or consent or refusal. So wanted to make sure that you had that. But now let's turn to replacement narcotic abuse treatment. So this phrasing, this terminology was added to state law in 1995. And it says minors may not receive replacement narcotic abuse treatment without the consent of the minor's parent or guardian. Now, before 1995, the statute said that minors were not able to consent to methadone treatment without parent consent. When they changed the language in 1995, they changed it to replacement narcotic abuse treatment. They also added to the statute a definition of LAM. So what does replacement narcotic abuse treatment cover? We know it covers methadone, we know it covers LAM, but the statute itself doesn't list any other specific names of medications. And I know that there are a lot of questions about, well, does this cover, what does this mean for the kinds of medications that we want to use for MAT? For better or worse, the statute does not provide that explicit list for us that some of you might want. So we're going to sort of come at that using another case. So Stacy's 16. She's brought to her federally qualified health center for her annual health exam. While speaking with the provider in private, Stacy acknowledges she's been using her parents' prescription for OxyContin for anxiety. She's running low, starting to feel anxious. Provider talks with Stacy about substance use, and Stacy decides she would like to be referred to some services but doesn't want her parent to know. May Stacy access services without needing parent or guardian consent? This hopefully is a relatively straightforward poll, so we'll just take a second with this one to see what folks say.
Yeah, it looks like folks are pretty consistent with their answers. And Rebecca, I also wanted to give you the 6-minute warning that you asked for.
Yeah, so I would say let's go ahead and close this one so we can keep moving forward. So the vast majority of you said that she may access services without needing parent consent. For sure. At a minimum, they can refer her to substance use counseling or medical care for an evaluation to see if she may have what the statute calls a problem. So let's say that she does go ahead to her local children's hospital, to their drug treatment program. I'm going to go ahead and skip this poll just so we can keep moving forward. So sorry about that, Kristen, but can she consent to evaluation at that program? Yes, she can. Can she consent to outpatient counseling? We know she can consent to any counseling that's funded through the mechanism that we put on the statute, the slide earlier. It's less about the type of counseling and more about the funding stream. She can consent to a physical exam, and she could even consent to inpatient hospitalization. Now, what if after multiple attempts at counseling and group therapy, they believe that MAT would be appropriate for her with, oh gosh, I'm not even going to try to say it. You all let this roll off your tongue, Buprit. For whatever reason today, it's not working for me, but you know what I'm talking about. May Stacy consent to this care on her own? The answer is no. This poll, I would love to see if we could do this one really quickly. What do you think the program should do next? They do want to engage. They do want parent consent. So do they tell Stacy to come back when she has parent permission? Do they contact Stacy's parents immediately? Do they offer to contact her parents and ask Stacy for permission for that? Or do they offer to contact her parents and ask for written authorization? So just take a second, tell us what your thoughts are on that. Looks like a number of folks are saying D. Yep, it looks like there's a lot of consistency in this. All right, so someone also said Z. C. Okay. So in some ways, this is actually a trick question because this circles back to confidentiality, and we did not talk about confidentiality law yet, but really wanted to highlight why, again, when we talk about consent, there's a lot of different layers. So consent to treatment, what we've covered today, is how we get someone in the door. But once we've engaged in treatment, like we did, we've engaged Stacy in treatment, and now we know that in order to take her to that next step, to Matt, we need to talk to parents. We actually need to know which confidentiality laws apply to the services that she's been receiving so far. So for example, if the services are subject to federal 42 CFR Part 2 rules, we would need her written authorization in order to talk to parents and get parent consent. If the information is subject to state law, we may only need to get her permission and not get written authorization. So consent to treatment law is what we've talked about thus far, gets us in that door, but it's really important to make sure we also then, in a second session, talk about confidentiality laws, because that's going to impact the kinds of referrals and the way we do referral, the way we collaborate, our engagement with parents, and it'll also let us figure out how we do billing and funding, because we may need to get explicit permission to bill certain insurance depending on confidentiality law in the insurance program. And with that, I wanted to take a real quick second to just flag, for those of you who may not be aware, we do have a specific state Medi-Cal program called Medi-Cal Minor Consent. It's anyone under age 21 who's still living at home is eligible to enroll in this program, and it will pay for services that minors can consent to. Eligibility is based on the minor's income, not the parent's income. It used to be quite challenging to enroll in this program, and it required monthly recertification. But now, during COVID, the state has waived some of those requirements, so it's a lot easier to enroll, and eligibility continues for a longer time. So this is something to keep your eye on if you need to help pay for minor consent care. And what I just want to flag is we are really interested in hearing from you what consent, confidentiality, insurance questions you still have burning that we weren't able to address today, the challenges that you're facing, because part of our next step is to try to create some more tools that help address these questions. So if you do have some suggestions or advice on what you'd like to see in those tools, I ask you to go ahead and go to the teenhealthlaw.org website and send them to me through that website, through the contact, or in the chat box today. Teen Health Law is also the website where you'll find any of the tools that I mentioned earlier. So we do have, this is what the website front page looks like. We do have some charts that summarize minor consent law. This is a chart that summarizes consent to treatment for youth in foster care, sort of who consents to what. We have a similar chart for youth and juvenile justice. So all sorts of different tools there. And I'm not sure, I know we're running out of time. I'm not sure if there's time to answer any specific questions, but I'm happy to do that if that's okay with you all.
I think go ahead, Deb. I was going to ask you if you want to hop on camera, and I'm also going to open up Victor's line.
Okay, great. Thank you, Rebecca. We are just about out of time. Victor, go ahead, and then I'll wrap us up, and we can stay a few minutes just to chat. Go on, Victor.
Okay, we just have a few questions, and the can a minor consent to take for an assessment to determine their status, which may identify them as in need of immediate care?
So minors can consent to diagnosis, and part of diagnosis is that assessment. We wouldn't be able to determine if they're mature enough to participate or if they're in danger or if it's an emergency if we weren't able to do some level of assessment. So yes, they can engage at that level.
Okay, here's another one. How often is the penal code updated, the Controlled Substances? Well, no. Well, I'm not sure if it's Penal Code or the Controlled Substances Act, but how often is the penal code updated, and does it contain newer street drugs or drug derivatives? Is vaping included in the penal code now?
So in terms of the drug or alcohol, the list of what minors can consent to services for, I think the most important thing is to keep your eye on the Controlled Substances Act. For vaping, it's less the mechanism they're using, a vape, than what they are vaping. So tobacco is not on that list. It is not considered a substance that minors can consent to addiction treatment for. But if they're vaping cannabis, for example, they would be able to receive services on their own consent for that. And the Controlled Substances Act is something at the federal level that they update or don't. Our state statute has not been changed in a while, and that is something to think about if folks feel like it is so behind in terms of the terminology or the kinds of services, the way that it even describes services.
We have a question that's a little different from some of the things we discussed when we were putting this webinar together, but what about the access to Narcan, the overdose reversal drug? The questioner says that pharmacists say they will not provide the drug, which is not psychoactive, it reverses it, will not provide the drug without parental consent to a minor. So I'm going to, first I have to say this is one of those questions where that line between legal information and legal advice becomes important, so my answer is probably going to be a little bit frustrating. But remember that the general rule is we need parent consent, and that's our default unless another law, an exception, allows us to give permission to a minor or someone else to consent. So we're going to ask for parent consent unless that minor consent law really explicitly authorizes minors to consent to a healthcare service. What minors can consent to is medical care and counseling for a quote-unquote drug or alcohol problem. They cannot consent to replacement narcotic abuse treatment. Where does Narcan fall in that spectrum? The statute does not explicitly provide definitions or guidance about how to treat Narcan. Is that considered medical care for a drug or alcohol problem, or is that something that we call narcotic replacement? You know, I know many of you have strong opinions on where it fits, but unless there is a statute or a regulation or guidance from our Attorney General or case law that explicitly says this is what Narcan is, I can't provide, I can't say more, but this is absolutely something to talk to your own legal counsel about and do sort of that risk assessment. And I do think it's a really interesting note that what you think may be different than what the pharmacist at the local pharmacy thinks. And this is where sometimes getting some sort of state-level guidance can be really powerful. So sorry, that's not a great answer, I know. Well, last question here. Are providers obligated to provide services to a youth who declines, but the parents consent and is, quote, forcing the youth into treatment?
So I have to say I've been working in this space for almost 20 years, and one of the questions I've received most frequently is exactly about that. What do we do when a parent's trying to force treatment and a youth says no? This is where, part of practice is law, but there's also ethics and professional responsibility and professional practice. And so, it is not my place to tell you what you are required to do, and practice is a lot more than law. Law sets sort of the basic bar for us about what we're allowed to do or what we're not allowed to do, but then, those other things are also really important. And this is also something where I think it's important to come back to your agency and see if there's some sort of guidance that you can create that takes into account all of that, sort of what is my professional obligation, what is my ethical license, ethical obligations as a practitioner, and make a decision on how to handle that. I know sometimes when I've done this kind of training in partnership with a clinician, what some clinicians will say is, it's really hard, particularly with a teenager, to engage in a service that the young person is not bought into. If they are absolutely resistant, even if we get them in that room, they're not going to engage with us. It's not going to work. So rather than sort of talk about how do we sometimes literally, tie them down to get a service delivered, how can we work together to convince them that this is the right thing to do? But I understand that that's not always possible. I don't know, Victor, actually, I would be curious if you've got some thoughts on that one.
Well, sort of. I mean, I know where the law came from. It was back in the 80s when what was known as the parent movement was strong in the country, and many parents, what's end what to do with, a teenage child who was using and out of control. And there were not many options there. And I know people did try to, and when I was administering the county alcohol and drug programs here in Santa Barbara County, parents would come to me. You've got to find some place to take my child. And someplace, it's a locked unit. And so there's a lot of interest in that sort of thing, but it never succeeded because of what you were just saying. I mean, if you don't want to be there, and certainly the folks on the webinar here know that if somebody does not want to participate, they're never going to engage. And, unless maybe you've got a judge out there and the judge says, you go to treatment or go back to jail, they'll come to the program, but will they convert to voluntary participation? And that's always the challenge. So I don't know how, it still happens today, but you're right about what you're talking about, Rebecca. It's like very difficult if you don't have a partnership, the therapeutic alliance with the client. So that was our last question. So I want to thank you very much for joining us here today. It was a very interesting, very informative presentation, and look forward to working with you some more on this. So,
my pleasure.
With that,
Thank you.